All right, welcome back, everyone. Let's move on to our next panel now. That panel is entitled Employment Litigation Risks in a Post-COVID World. Let me introduce our moderator for that panel, Melissa Raphan. Melissa, take it away.
Thank you very much, Ryan. Good morning and welcome. I am moderating today's sparkling panel. And if we take a step back and take a panoramic view of the last 12 months, we can see three very distinct phases as it relates to the employment litigation workplace. Phase one was shock and the sudden move to remote work. Phase two brought legislative efforts in reaction to the pandemic, for example, the FFCRA. Phase three brought an adjustment to the new lifestyle. And we are now entering phase four, the big return. As we prepare to move forward, let's look at the current state of employment litigation. I think it's really best summed up by the opening paragraph of a federal court decision on an employer's motion to dismiss an FFCRA claim, Sanchez v. Tree Smiths. And the opening paragraph of this decision reads like a dystopian fairy tale. The court says, this case presents a unique scenario that is indicative of the unprecedented times in which we live. In the beginning of the COVID-19 pandemic, when schools closed, and it continues from there. So that's how the judiciary is looking at these cases. At the same time, courts have been relatively, have pressed the pause button and they have seemingly just released it. Generally, federal courts are planning to resume in-person civil jury trials and accordingly, accompanying that are hearings in the May and June timeframe. But it's jurisdiction by jurisdiction, it's court by court, and it's in some places judge by judge. For example, federal courts in Minnesota, Texas, Illinois, New York, and Utah say that civil jury trials will resume in the May to June timeframe. In Texas, it's division by division, and in the Southern District of New York, it's judge by judge. State courts are pretty similar. Minnesota is going to resume civil jury trials mid-June, Colorado in April, and New York, believe it or not, is up and running. So the place where litigation occurs is just starting to ramp up again. At the same time, we have a couple of additional facts to contend with, that many employees have settled into their new lifestyles, which does not involve a return to a brick and mortar. And in some cases, employees don't intend to return to a 40-hour work week while getting paid for a 40-hour work week. We also have new workplace claims. Some of them are brand new based on the new litigation, and some of them are new fact patterns based on existing claims. So I personally predict an explosion of litigation, and I don't have a crystal ball, but that is what I think is going to happen. I think once the pause button is released, we're going to see very active plaintiffs' lawyers return to their what they consider to be their rightful place in the courtroom. With me to walk you through today's program are my stellar colleagues, Trevor Brown, Marilyn Clark, and Jack Sullivan. Let me start with Trevor Brown. I would ordinarily say to my left, but I can't tell where he is exactly. He is a very highly valued member of our group. He has very significant experience representing financial firms in the FINRA context, involving disputes about customer non-solicit, and advises advisors on expungement. Advises employers on advisors' requests to expunge. He assists employers with every size, with every issue conceivable, including trade secrets and non-competes, and works closely with clients to provide very practical solutions. Having taught math to middle schoolers, he can make the very complex very simple. Marilyn has a very calming influence on all around her. Opposing counsel and clients alike find her to be soothing. At Dorsey Partners, she has particular expertise in helping employers navigate complex statutory compliance and litigation matters in the wage and hour, leave, and accommodation contexts. Her prior experience as a manager and embedded in-house counsel gives her a very practical and business perspective when resolving real-life issues. Jack Sullivan is a just the facts guy. He joined us having been a journalist, and his briefs really sing. Highlights of his journalism career include a reporting trip to a secret military base in the Persian Gulf, and when a congressional reporter, he stepped on a US senator's dog. If you can pull that off, you are unflappable. He has a wide-ranging practice of employment litigation and counseling and advises employers and union relationships, has led contract negotiations and represented clients before the NLRB. I am a student of the workplace and have seen and heard many things that were better left not seen and not heard. I do love employment litigation because every case is a new story to be read and told. We have a very ambitious agenda for this morning, and as it relates to the Biden administration's post-COVID priorities, we could be doing a whole seminar on that, but it is taking a backseat to COVID, and we will feather it in as we speak. The big return is really to walk you through issues to watch, and we all know that the road to litigation is paved with good intentions, and our hope today is to help you avoid the landmines that exist in phase 4, the big return. I'd like to invite you to put questions into the chat. Tell you there are a lot of case sites at the back, so if we reference any cases, don't worry that you can't catch the site because you will find it in the back. And I'd like to ask Jack, kick it off with the first question. When will employees return, Jack, and what is that going to look like?
Morning, everyone. We wanted to start today by setting the scene of US workplaces. And a big part of that is answering Melissa's question, when are people going to be returning to their brick and mortar workplaces? A recent survey of 350 CEOs and HR and finance leaders indicated that 70% of those respondents expected to have employees back in buildings by this fall. What that is actually going to look like, of course, how many employees are back, how often they're spending time at their office versus the home workplace that they've gotten accustomed to over the last 13 months is an entirely different question. As you can see here, there are many companies that have made it clear that going forward, their employees are either going to be working from home all the time or some of the time. In the Minneapolis area and across the street from where we are, Target Corporation announced that the 3,500 employees who otherwise took up a great share of one of the distinct high rises of the Minneapolis skyline would not be returning to that workplace at all, and instead would be working on a hybrid remote in the office workplace at other Target locations in the Twin Cities area. Target isn't alone in that. You may have seen that Google is considering a September 1 return to the workplace, but for that, there's going to be an expectation that employees are physically present 3 days out of the week, and 2 days of the week they would not be present and would be on a remote footing. PwC is somewhat similar. They again have targeted September to have all offices open, but the status of how and where those employees are going to be working on a Monday through Friday basis is yet to be seen. We know that many of you are going through these evaluations right now. You're deciding when and how to bring people back and applying the lessons that you've learned over the last 13 months to decide the answers that work best for you and for your workforces when answering that question. If we could go to the next slide, please.
Yeah, what do employees think of their new lifestyle?
There is, there's really been a sea change. There are, before the pandemic, a survey done by Pew Research had indicated that fewer than 1 in 10 workers were in a flexible workplace situation. And as I think we all would anticipate, those were mainly white collar professionals, mainly managers, and mainly people at the top of the organizations. But now that's exploded to the opposite. 7 in 10 employees who can do their jobs at home are doing their jobs at home. I think any of us who have called a customer service line in the last 13 months know that these are the light blue collar workers in many cases, the public facing customer service representatives, HR personnel. I mean, really everyone who might have had the expectation set that they need to be in the office on a regular basis have obviously learned that that is not necessary, and they've been performing their functions to a dramatically different degree at home than had ever been done before.
So Jack, do people want to come back? Are we going to see
There's
litigation about that?
there's a couple sides of that coin, Melissa. There's sort of the demand and the expectation that exists among the workforce. So, on the demand side, we have more than half of employees are wanting to continue to work from home on some basis, according to the same Pew survey. And the expectation of, again, about half of employees are that they will be allowed to do so. And that percentage, when you look at different industries, is even higher when you look at tech and finance and media, and there's higher percentages than that roughly 50% threshold for what people expect. And on the employer side, a Cushman and Wakefield survey of employers in 35 markets across the United States indicated that about 8 in 10 employers anticipate some sort of work from home model for their workforces going forward.
Is it fair to say that employers will have potentially a more difficult time arguing work cannot be done remotely based on the experience of the last 14 months?
I think that's absolutely the case. And Melissa, you may remember that you and I worked on a case that involved a IT manager who argued that he should be allowed to work from home as an accommodation for a disability that he claimed to have. And there was a strong indication from the employer in that case that the work was not able to be done from home. And I think what we've all learned over the last 14 months is that there is a lot of work that we used to think could not be done from home that obviously can be done from home. And so when that layers onto a reasonable accommodation analysis, there is going to be a very different argument and a different set of facts that employers will be looking at. And if we could move to the next slide, I was just going to take a couple minutes to review give an overview of some of the regulations and laws that we'll be turning to next. And the first is as we heard about in the presentation that preceded us, there are now, for some employers, an expanded leave benefit under the extension of the FFCRA. There are anticipated to be an expansion of unemployment benefits, which for some unionized employers has a very different impact on how they approach their labor negotiations, because most of the unemployment benefits that are expanded under the federal legislation as that flows down to the states the analysis does not determine or is not based on the reason why an employee is receiving unemployment benefits. And so in those states where it is lawful for an employee to request and receive unemployment benefits in the event of a lockout, then there is the automatic addition of that money on top of the benefit that they would otherwise be receiving. So that's something, an unintended consequence most likely, but it certainly changes the strategic evaluation in a unionized context of the pressure that an employer would bring to bear by engaging in a lockout. We've all, I think, heard a lot about the EEOC's guidance and the information that it has put out about whether employers may mandate vaccination among their employees before those employees return to the workforce. We'll be getting into more details about that through the course of this presentation, but It's a question that has a on one hand, very simple answer, which is yes, you can, and a much more complicated answer, which is, do you really want to? And what is the effect of doing it? OSHA will talk a bit
And
about.
could I just, oh, I'm sorry. I was just going to say, just on the mandatory vaccines, there are not a lot of cases that have been decided on the mandatory vaccination front, but there are two that are cited in the materials. And just to point out, one involves mandatory flu vaccine, and a gender discrimination was brought by a pregnant woman saying that mandating a vaccine which could potentially harm unborn children has a disparate impact on women. There's a great analysis in there that courts may look to in the context of the COVID-19 vaccine. There's also a case in which a court denied a TRO by an employee to prevent his employer from forcing him to get the vaccine. The employer had said, if you don't agree to get the vaccine, we're going to fire you. When push actually came to shove, the employer backed off and gave him a non-disciplinary counseling memo. And so the court said it wasn't right to rule on the TRO. But I think we can all imagine a lot of scenarios around that mandatory vaccination and how it's communicated and how it's enforced in the workplace, to your point.
Another thing that we will need to be aware of is the application of existing safety regulations set by OSHA and state safety and health boards on workplaces. And the fact that COVID is now a known and foreseeable risk, and how that factors into what would typically be a safety analysis. And we'll get into some of the details of what many of you may have seen. Earlier this month, OSHA issued a sizable fine, more than $130,000, on a public-facing business, a tax preparation firm that was not following CDC guidance and was fined as a result for the risk that was posed to employees and to the public. And then on the next slide, those of you that are unionized or have dealt with a union campaign have, I'm sure, worked through many issues in your union relationships and the application of the general duty to bargain with the representative of the unionized employees for anything from shutdowns and the impact of a workforce shutdown, and more recently, the requirement for a vaccine being a term and condition of employment that would be subject to mandatory bargaining. People may have known, if you have had the experience of a union vote in the last 13, 14 months, the board has always had the discretion to order mail-in balloting for union elections, and they have in almost all circumstances done that in the last, through the course of the pandemic, even when both the union and the employer have sought an in-person election with proper safety protocols. The board has exercised its discretion to order mail-in balloting, which really changes the kind of internal political dynamic of the employer's campaign and the union's campaign. The PRO Act we mentioned here just as a place that a vehicle from which more employers might end up in a unionized situation. So the PRO Act is legislation that had been passed by the House of Representatives under the previous during the previous Congress, did not advance in the Republican-controlled Senate. Obviously, with the Democratic control of the Senate, there is the expectation that the PRO Act would be something that would be brought up and could be decided. It has the backing of the Biden administration. And generally speaking, it is something that would really lower the barriers to union organization and limit the sorts of things that employers can do in response to a unionizing campaign. And it's, so while there are many aspects of the National Labor Relations Act that apply to all employers, regardless of whether they have a union or not, the PRO Act, if it's enacted, is something that might have the effect of increasing the proportion of US businesses that have unionized workforces. And Melissa, as you've already indicated, you have your finger on the pulse of litigation trends and what people have been seeing and what we've been seeing. And so I will turn it back over to you to enlighten us on current litigation trends.
Well, I think you're kind to say I have my finger on the pulse. I think I have my finger on my own view as to what's going to happen. But what I will say is I monitor the dockets of a number of different states, and I don't believe we have really seen the COVID-19 litigation in the employment context in the way that we're going to see it going forward. The cases that have been coming out recently, like first quarter 21, really relate to fact patterns that occurred in, Q2 of 2020. So we are seeing decisions on, how employers were handling workplace issues right at the beginning of the pandemic. And, I think the disadvantage for employers is that the cases are being decided now, 12 months later, when everyone has a much better read. And reading the decisions, you can sort of see the state of panic that employers were in. So I really think, Trevor's going to talk about EEOC charges and EEOC litigation, which is very helpful. But I think we're going to see kind of two distinct strands of litigation. We're going to see what we saw before with, kind of a new spin based on COVID-19. And then we're going to see the brand new claims that we anticipate, under the new legislation. The other thing I'll just say from kind of the litigation perspective is that the courts seem to be really enjoying the remote environment. And, Michigan Supreme Court Justice noted that the pandemic was not the disruption that any of us wanted, but it might be the disruption we needed. And I think everyone would say that the legal profession is not cutting edge when it really comes to anything. And forgive me if anyone disagrees with that, talk to me offline. But we really got a kick in the pants and we're not going back. That's really the bottom line. We're never going to go back. So I think we should take the best of the last 18 months and carry it forward as it relates to employment litigation, because that's going to be the path forward. So as we do the big return, Marilyn, it seems like employers need to carefully consider each step of the way to minimize litigation risk. And what's the first step? Help us out.
Thank you, Melissa. With the vaccinations rolling out and employers beginning to plan for a broader scale return to brick and mortar workspaces, how this return is managed will be substantially important, as there will be a new spectrum of litigation risks associated with many aspects of the return to work process. As a threshold consideration for most employers, once the option to return to the workplace is available, employers will need to consider whether all workers must return or whether a work from home option will remain available. As we've discussed here today, trends are suggesting that employees are expecting that an option to work from home or telecommute will remain available to them going forward. And in determining whether that option will be something that's feasible going forward, employers should first consider CDC guidelines on considerations about a general return to the workforce, even with the availability of vaccines. The CDC has recommended that employers consider the necessity for employees to physically return to the workplace and whether telework options reasonably can be continued. If that option is something that is available and can be continued, it remains a viable measure to continue to stave the progress of transmitting the coronavirus. The CDC has also recommended that employers keep their eye on the level of transmission, how many infections there are and how fast it's spreading. And if the infection transmission rate remains high, even if the option to return to the brick and mortar workplace is available, employers might want to consider leaving a telecommuting option available. Employers should also consider the reasonable ability for employees to practice social distancing and other prevention measures, such as wearing masks in the workplace. And of course, employers need to be aware of local and state mandates related to business closure restrictions. So obviously, safety is going to be a primary concern in return to the workplace. We're going to speak a little bit later about some of the specific concerns in that arena that employers need to be aware of in order to mitigate litigation risks. But leaving a telecommuting option available as long as there is still risk of transmission is a measure that the CDC continues to encourage employers to consider. With respect to threshold screening issues that employers may consider with respect to bringing employees back in the workplace, while employers may look at whether employees have received a vaccination or whether employees have received or have been diagnosed with an active case of COVID-19, they may not look at whether employees have been tested for antibodies in their system. A test for antibodies under the CDC is under CDC guidance is something that employers should not use to make decisions about return to the workplace. And in light of that CDC guidance, under the ADA, employers may not require antibody testing. So it'll be important for employers to be following what CDC guidance is on specific factors related to testing, vaccinations, issues of that nature, because the ADA, according to the EEOC, is going to be tracking CDC guidance and determining what is permissible in terms of bans from the workplace.
Marilyn, is it fair to say that depending on size, employers might need COVID-19 subject matter experts to stay on top of these issues?
Absolutely. That seems like a critical decision that I would say all employers should consider making in terms of remaining aware of the shifting landscape in terms of CDC guidance, agency guidance, evolving statutory restrictions and provisions, as well as the litigation risk as it begins to unfold. Having one person, a point person, or for larger employers, even a team of people assigned to stay on top of the issues will be a critical measure in terms of mitigating risk going forward.
So what are the pitfalls that employers should be sensitive to?
So in considering a work from home option, beyond looking at the CDC guidance about whether employees should be brought back into the workplace, if a decision is made to move back into the brick and mortar location, and the employer is considering allowing some, but not all employees to work from home, employers may face increased liability risks if they are denying work from home options to disparately impacted populations, such as women, and also to employees with disabilities. So looking at the first group, employers are warned to beware of the she session. While the 2008 recession came to be known as the man session because more men were impacted at that time, C. Nicole Mason, the president and chief executive of the Institute for Women's Policy Research, has dubbed the COVID impact on unemployment rates a she session because the pandemic has had a disparate impact on women. Based on Bureau of Labor Statistics, excuse me, for 2020, women have lost a net of 5.4 million jobs during this recession, nearly 1 million more job losses than men have experienced. And minority women in particular have been impacted very dramatically. Job losses as of December are a stark illustration of these trends, showing that Black, Hispanic, and Asian women accounted for all of women's job losses that month, and 154,000 Black women dropped out of the labor force entirely. And this disparate impact has been attributed to push and pull factors. First, women are being disproportionately pushed out of work because industries dominated by women have been hit the hardest by the pandemic. And second, women have been disproportionately impacted in terms of joblessness because they've been pulled home to care for others. On the push side, industries such as travel, live entertainment, bars and restaurants include a workforce in which women previously made up 53% of that workforce. So with the heavy impact of the pandemic on the entertainment industry generally, women have experienced a harder hit. Childcare closures and non-essential medical jobs, including home caregiving, also include a disproportionate number of women in that workplace. 77% of women of the workforce rather is made up of women in education and health services industries. Less tax revenue during the pandemic has also impacted government jobs, and women make up a majority of government workers as well at 58%. And in that sector, Black women make up 18% of the workforce, again, leading to a disproportionate impact on minority women in particular. On the pull side, women have been pulled back home to serve as caregivers due to the collapse of care networks, daycares, distance, and the need for distance learning. They've been pulled out to care for sick family members, as well as immunocompromised family and household members. So some employer solutions to help mitigate the risk of potential disparate impact claims by women in the workforce, or just claims generally that a work from home option has been denied because of a protected class, such as gender. Employers should seriously consider flexible work requests and permit work from home options if it's reasonably possible. Beyond just the safety concerns, the ability to mitigate risk of litigation increases substantially if employers are willing to consider flexible work arrangements where possible. If flexible work arrangements are not possible, posting work schedules in advance to allow female workers to secure childcare and to arrange for options to care for family members and to help cover other demands on their time from the caregiving perspective is a way that employers can work with to help women plan for and manage those outside demands in a way that allows them to remain in the workforce. Employers should also create strong workplace health and safety protections to mitigate the impact on women as caregivers generally, and we'll discuss some of those options a little later on, as well as strengthening and enforcing policies against discrimination, harassment, and retaliation in the workplace generally. Employees, oh, I'm sorry, go ahead.
I was just going to say, I think that we're going to advance the slides. I think we're going to advance to the next slide, please.
Okay, and so we're moving on to the imposition of mandatory vaccines, and Jack was going to jump in and give his expertise on this area.
As I mentioned before, there's a simple and a complicated answer to the question of whether an employer may impose a vaccine mandate on its workforce. The EEOC guidance on the question is an absolute yes, that requirement may be set by an employer. But before any employer sets that requirement, there needs to be a careful analysis of what the result of that requirement is going to be and what you are willing and able and willing to do as that requirement plays out across your workforce. And I think it's really a consideration of who are your employees, what do you think the response to that requirement is going to be, and what are you going to do if a sizable percentage of your employees refuses to follow the mandate. And that might be a very different question from employer to employer, but to impose a requirement that then is not abided by 5 or 10 or 15% of the workforce might result then in a need to respond with discipline, potentially termination in response to people who have refused that mandate. So that's sort of, I think, one of the most practical thought analysis to go through when you're considering whether to impose a requirement for a vaccine. When the requirement is set, then the typical analysis and response to employee requests that all employers have to do in other contexts apply here, and that is responding to accommodation requests. So, what we would anticipate more than any other would be a religious accommodation request or a disability accommodation request. Potentially, someone has because of the tenets of their faith, they have a sincerely held reason that would compel them to not get vaccinated. Or under the ADA disability analysis, there's an underlying medical condition that affects their ability to receive the vaccine safely. The requirement that that would apply typically to an accommodation request sort of either category would apply here, with the caveat that there's always going to be a need to take care with the sorts of requests that you make for information to demonstrate the need for the accommodation on the disability side. And under the religious accommodation side, the careful attention to the requirement that it's not up to you, the employer, to determine whether the avoidance of a vaccine is a tenet of faith of the person's belief. The question is whether it's a sincerely held belief on their part, and is it being put forward in that manner that therefore it merits your respect. There was a question earlier in the chat, and a big question I think that we all would anticipate is, okay, if you have the requirement, how are you going to make sure that people have followed the requirement? What can you ask for? And so the request for seeking proof of vaccination is a careful one, and the response needs to be careful, I should say. You can ask for proof that someone has received the vaccine. You need to be absolutely clear and absolutely avoid requesting any medical information beyond what would be otherwise required just to simply demonstrate that the vaccine has been administered. So if there's any, there's medical records that might otherwise be kind of in the purview of what you're asking for. I mean, it's a very narrow question. Have you received the vaccine, yes or no? And do you want to ask, show me the card, show me the minimal amount of information that I need to determine whether the vaccine has been administered.
Jack, there was also a really good question that we got a little bit ago about whether a person's vaccination status is a protected classification, and the call of the question was really, can we disclose that to our customers? So, hey, this particular employee, Trevor Brown, has been vaccinated. We want you to know that when he comes to visit you at your home, which gives rise to a host of employee privacy concerns. So I wanted to at least flag that for our consideration. And I'll take the first whack at it, that a general announcement to customers that we require our employees to be vaccinated before they come into homes, if it's a home-based or an in-person based sort of thing. So a sort of public announcement that this is what our company policy is. Obviously, that's going to put you in far less trouble than calling up a specific customer and saying, hey, your specific person from our company who's coming in has been vaccinated or has not been vaccinated. But I wanted to flag that while we're talking about mandatory vaccinations.
Thanks, Trevor. And I think your first crack is the full crack. That's a great answer to the question. The disclosure of any individual employee's medical information, health information, vaccine status is a far different question than letting an interested group of constituents, whether that's other employees or whether that's customers, that this is the requirement that we've set. And these are the people who are interacting with you, and you can sort of draw the inference from those two events that the people that you're interacting with are most likely vaccinated. Whether the person who actually is coming out to a customer site has received an accommodation that has allowed them to not be vaccinated is a much different question, and something that, unless there is a direct threat analysis that would be required, sort of the things that might really bring to bear as to whether that non-vaccinated employee who received the accommodation can continue to perform the functions of their job, is really a very fact-specific sort of analysis. But I think your general approach is exactly right. We would never, the announcement to anyone of any employee's medical information, vaccine status is something certainly to avoid.
I think we now have the topic for our next client briefing, which will be mandatory vaccines in the workplace. And we'd like to advance to the slides regarding the EEOC charge information. Thank you, Trevor.
All right, and we did skip a lot of good content. I think the slides were distributed. There are definitely a lot of litigation risks and pitfalls to watch out for that could probably cover a day's worth of presentation. So we include some EEOC charge statistics on this screen and then the next slide as well once we get there. And I think this is really helpful for employers really of all sizes and across the country to see, because it shows you, this particular slide shows you what employees are focusing on. So when we talk about litigation risks, this is what employees are doing. This is the kind of litigation that they're bringing. Now, EEOC charges don't necessarily correlate to litigation, but they're a pretty good indicator, a pretty good first step. And so we have up here historical information from 2017 to 2020. The EEOC makes all of this information available, but we do want to point out some trends. The first is the first row, total charges, and you can see it's a downward trend, pretty clear. The 2020 number of charges, 67,000, is the lowest that we've seen in 2 decades. Total number of charges coming into the EEOC are just simply on the decline. And I want to talk about that in just a second, and maybe we can get some insight. But to round out the numbers here, you can see that the number of race discrimination charges, or charges alleging race discrimination, sex-based discrimination, age-based discrimination, they're kind of holding steady. You know, some fluctuations, but by and large, they're holding steady. I should make a quick note that if you're quick on the fly with the math, you'll see that my percentages don't always add up to 100. That's because obviously some charges can contain more than one allegation, and the EEOC counts them all together. The interesting things to note are that disability is ticking upward. It's continuing to tick upward, and as Melissa noted earlier in our presentation, with COVID litigation probably coming as opposed to having already arrived, I would expect those 2021 numbers, once we get them, to continue that upward march. Another thing to note is that retaliation is the highest and continues to be the highest. And so that shows you that continuing through into the COVID pandemic, employees are really concerned that their employer is doing something bad to them because they engaged in some sort of protected activity. Retaliation covers all of the EEOC's version of retaliation covers all of your Title VII, ADA, et cetera, type charges. So this wouldn't necessarily be just a pure whistleblower claim under, say, the Minnesota Whistleblower Act or something like that. This would be retaliation under the Title VII and related statutes. So,
and I would just add, Trevor, that I think there's going to be an incredible uptick in OSHA retaliation claims. I think we've seen them throughout the pandemic, but I think we're going to see a huge spike when people return for all the reasons Marilyn said.
Yeah, and before we move on, the number that I really want to talk about, the one that jumped out to me, is that 67,000 charges in 2020, and the 2-decade low that we're seeing now. Maybe we could make some excuses because the EEOC suspended some of its operations, suspended some of its notice of right to sue. And if you have more employees out of the workforce, they're going to be filing fewer and fewer charges. But I don't think we can chalk too much of that up to COVID necessarily, because employees were getting laid off in 2020. They were getting furloughed in 2020. All sorts of adverse actions that would give rise to a charge were happening in 2020. So I don't know that we can attribute too much of that to COVID. It's just that the number of charges are going down. What we don't know is whether that is reflective of the prior administration. And so maybe those are going to tick up. If there's a perception that the Biden administration's EEOC is going to be more receptive to charges, it's going to be an interesting trend to watch. But the key takeaway here is that employees are most concerned about disability discrimination, and that's only going to continue. and most concerned about retaliation, and that's only going to continue. So those are the key areas of risk for litigation for employers going forward.
And I would, Trevor, I would say this is going to sound tongue in cheek, but it's very sincere. When the kids go back to school, the charges are going to get filed. People have just been too distracted to file charges. And I think personally, I think our 2021 is going to see a huge uptick.
Yeah, definitely a fair observation. If we could go to the next slide. This is the counterpart. So the first slide was charges that employees are filing or bringing to the EEOC. And then this slide shows you what the EEOC is doing about it. The number of merit suits that the EEOC has brought or subpoena suits that the EEOC has brought. And this is another piece of valuable insight for employers, because what litigation the EEOC is bringing is definitely indicative. And again, we'll see the total number of suits is going down. This one, I do think we can chalk up a little bit more to COVID. 2020, that 97 number of lawsuits, that probably has a lot more to do with the EEOC starting to shut down operations, with courts kind of at least making operations a little bit more difficult. So I would expect that number to tick back up once we get into full swing in 2021. This number, this downward trend also is probably easier to attribute to the prior administration. All signs point to a Biden administration's EEOC being a little bit more litigious, but the numbers are important as well. The Title VII suit, so this would just include your discrimination and your retaliation outside the context of age discrimination and disability discrimination. That accounts for most of the EEOC's litigation, and it's going to continue. ADA, that's the Americans with Disabilities Act, that tracks with what employees are bringing to the EEOC. Employees are bringing disability discrimination claims, and the EEOC is continuing to litigate them, albeit on a downward trend, but that's still, the second biggest one that the EEOC is after. I'll say a quick word on subpoenas. For those of you who have been involved in EEOC charge responses, you'll know that the EEOC sometimes asks for more information than we want to give them. Sometimes the EEOC will say, okay, fine. But sometimes they say, no, we really want that, and we're going to take you to court and subpoena that. Those numbers kind of were holding steady, 8.5, 8.3. They took a big tick down in 2020. Again, I think that's probably fair to chalk more up to COVID and to EEOC suspending operations. I would expect that to jump back up. So it's not a huge percentage, but it's a good reminder for employers that sometimes the EEOC asks for stuff and they really mean it, and they're going to take you to court. Sometimes not. So it's a good point to watch out for. The one piece of information that's not on this slide is that EEOC recoveries have gone up. So by about $100 million, the EEOC is recovering a lot more information. So fewer suits, but getting a lot more dollars in.
Okay, Trevor, that was your final, what you're leaving with the audience. The proverbial hook remotely is getting us. So Jack and Marilyn, please give your parting thoughts to our home audience.
So I will just dovetail on Melissa's comment that OSHA claims and OSHA litigation is likely to be a key area in which employers face risk going forward. During the coronavirus, OSHA's enforcement has been driven primarily by employee complaints, and the key areas that the agency has received complaints in offer a nice guide to areas that employers should be focused on to help mitigate risk. So employees have been focused on the failure for employers to implement a detailed risk assessment and site-specific protection plan, failure to implement or enforce social distancing policies, failure to maintain injury and illness prevention programs, insufficient workplace cleaning and sanitization, and then interestingly, failure to provide employees with safety data sheets for new sanitizing chemicals introduced in the workplace. So just key areas for employers to be aware of in terms of ensuring a safe workplace and mitigating risk of employee whistleblower complaints and OSHA enforcement action going forward.
Jack, close us out.
My parting thought is think very carefully when you're deciding whether to mandate a vaccine to your workforce from your workforce. Think through all the impacts of that before doing it.
Thank you all. We got fabulous questions that we weren't able to answer, but feel free to reach out to any of us to get your answers, and enjoy the rest of the session. Bye-bye.
Thank you, Melissa, Marilyn, Jack, and Trevor. Very good information, very timely as always. All right, this time we're going to take a 10-minute break, give you a little bit more time. I'm being told, to be more precise, exactly 9 minutes, not a second more. Anyway, we will be back at 10:40 and hope to see, well, not see, hope to have most of you coming back. See you soon.